first of all, good morning, everyone. I know this is a very dreary day, but we really do appreciate everyone joining us. And this is something a little bit new for me, is the presentation via webinar. I feel that I'm much better in person, but I'm working with the media we have today. So thank you again all for joining. So if you have any questions that are relevant to what I'm presenting on, please put it in the chat. And then again, if it's relevant to what I'm talking, I'd rather address that immediately than wait to the end. So I know I looked through the participants and I know I recognized some of the names, but not all of them. I would like you to know that I'm very approachable. I've been with the department for, just a little bit about me, I've been with the department for, I think, almost 24 years. I have been in litigation for most of that. And so most recently, about a year ago, I was asked to be the chair of the Board of Appeals. So I took that over, and I am making some improvements along the way, but I really look for feedback from people who utilize the board, which is most of you who are your clients or yourselves. And I am very approachable, and I would like you to contact our office if you have questions. Our general number is area code 312-814-3004. So please give us a call if you ever have any questions. I would welcome that. Okay, so getting started. The Board of Appeals was created through and operates through its enabling statute, which I've listed the link for you if you want to go in and check that out. But that's basically what gives us our authority and our authority to act. And our mission, which this is relatively new, trying to really improve the board as I go along. And so our mission is really to take final department controversies with regards to tax liability and provide an equitable solution or relief where it's appropriate. I do believe very strongly that there are circumstances that taxpayers find themselves in that do warrant some sort of relief. So, okay, so under our enabling statute, the Board of Appeals consists of 3 members. And so all of those members are appointed by the director. 1 member, the chair, that's me. I'm responsible for overseeing the daily business of the board, including our policy-related matters, the resolution of cases, and case management. So very similar to what Melanie had said is, you know, I'm overseeing the entire administration of the board, both procedurally and substantively. And the 2 other members that participate in the board's decisions are the board members. And so currently the board members are Alexis Overstreet, and she also serves primarily as the Deputy General Counsel for Sales Tax. And then Stephen Hayes, who many of you may or may not be familiar with. He's been with the department a long time as well, and he is the Collections Bureau Manager. So typically the way that it works is my hearing officer writes up a recommendation, I review it first, and then depending on how many signatures that order needs, then it goes to Stephen and then to Alexis. Next slide. There are the reasons why cases come to the board is because there are assessments that can no longer be challenged on the merits because the protest period has expired or the merits have been adjudicated by way of some other final judgment or administrative decision. And so a lot, kind of just piggybacking on administrative hearings. If a late discretionary is denied, most often we will see that person then come to the Board of Appeals. It's kind of the last stop for any taxpayer who is trying to get some relief granted. So getting back to the board's jurisdiction, we are bound to final assessments, final determinations. So, for example, if you are still in audit or you are still litigating either at the tax tribunal or administrative hearings, we will not take your case. And also, I think perhaps there have been some past practices of we'll just file at the board and let it sit there until something's been finalized. I'm trying to steer clear or away from that kind of type of activity at the board, just because I feel as if the only cases I want at the board are the ones that we are actively working on. So just to, for lack of better words, park your case at the board while you're waiting for a final assessment or a final adjudication. I'm not allowing that any longer. So just maybe take note of that. Additionally, there are some cases, and this is again in very extremely rare circumstances where the director expressly orders me to take jurisdiction, or all three board members agree that there is a special finding for special jurisdiction. And so that has happened. I sat on the board before I was chair, probably I think for 4 years. And I think I only remember one circumstance, and it is very rare, and it just comes up not very often, but it's just something where the facts are just extremely rare or unique, and the only way that there's an equitable solution is if the board takes special jurisdiction. Next. Okay. So the board hears two types of cases. The first one is an offer in compromise, or we refer to it as an OIC. And that's where the taxpayer is asking for relief based on financial, medical, or some other hardship. And then there is the reasonable cause cases, the RC cases, where the taxpayer is asking for solely relief in penalty and or interest. So one caveat on the offers in compromise is that only the director of revenue tries to actually compromise those debts, subject to the full board reviewing them. And so, you know, a lot of people think it's the chair who really has the final say, and I will say the director does defer to me, but just so you know, he is the one with at this time, the director, Harris, is the one with final authority, and so he does sign off on those cases. And with regards to reasonable cause, this only applies to penalty. There are some examples where we can, because we are a forum of equity, address interest reduction. That's in a very rare circumstance as well. And that usually happens if there's some sort of showing or we can see internally that, you know, the department just didn't get it right. And there were some timing issues, you know, they have to be pretty substantial timing issues. But, you can always ask for it. That's a little bit harder to get versus reasonable cause. And reasonable cause is provided in the statute that I've cited here, and then you can always look to the rules at, I think they're 700.400. I think that's where the rules are located. Next slide.
Rebecca, if I could interject real quick, we have one question. The question is, for OIC, is there a list of allowable expenses similar to what the IRS has? Meaning, if a person is only bringing in $2,000, do you allow $1,200 for housing, $300 for food, et cetera?
Thank you for the question. We don't have a specific set of what's acceptable and what's not, but what we do ask on offers and compromise, and here's kind of the just the mentality behind an offer and compromise as far as I'm concerned, is you're coming to the state to ask them to relieve your liability to the state of Illinois. And so with that comes the showing of true financial hardship or an accurate accounting for what your expenses are. And I'll get to the forms that we ask to be filled out for the offers and compromise. And so I'll come back to that so that I can talk a little bit more about specifically a BOA 4, which is the financial disclosure for individuals, or the BOA 5, which is the financial disclosure for businesses if it's an ongoing business. With regards to the time frame for cases at the board, at the time that I was editing this slide, we were approaching 1,000. I think we're over 1,000. And we're only, midway through October. So there are a lot of cases pending at the board. And so we do our best to get once the case is filed with us, to get it on its way within the board. And so depending on what the staffing issue is at the time, that might delay the docketing of your petition, but I think that we're doing a pretty good job within the last year of making sure that those cases get docketed immediately and then move on to a jurisdiction review. There are some circumstances that require the board to act more quickly with regards to you or your client's specific matter. And so I will take that into consideration. A lot of times it's, like I said, a serious illness, a foreclosure, someone's closing on a house. I know that was one we just kind of moved to the top of the heap because they needed to close. But if you find yourself in that circumstances or your client is in that circumstance, please reach out, because I really do make an effort to move that and get that assigned fairly quickly. I can appreciate kind of this is the end of the line. And so with that also comes some timing issues for the taxpayer. However, with that said, I don't want to guarantee that I will move it, because a lot of times what your client's emergency is not really an emergency. And what do I mean by that? I mean, when I can see that notices have been ignored for a long period of time, or that, for example, their liability was just finalized, you know, something like that doesn't necessarily make your client's emergency a real emergency. But I do take all the facts and circumstances into account, and I really do try, if it's warranted, to move it to the top. But as you can imagine, with those matters pending, everyone wants to be at the top of the heap. if you will. So I really do, try to weigh, is this, next slide.
Rebecca, if I could again, does this board only focus on individual or corporate taxes, or do they go clear down to something like exemption hearings on sales taxes?
We address any tax that is administered by the department. So sales tax, use tax, excise tax, IFTA, RUT 50s, RUT 25. We hear it a bit, withholding, NPLs, 1002Ds, we hear it all. Any finalized liability through the department, we will address for any tax. Okay, with that being said, there are cases that we do not hear and we will not take and seek and offer relief, and that's the release of lien. Although, again, if something is resolved via the board and there is a lien and that lien is causing the taxpayer to not be able to do something, then we will oftentimes help facilitate the lien release by kind of, sending our final order so that the lien release unit can see, okay, we can release this and free up whatever the lien was on. And also, we will not reverse a revocation order that is for administrative review. We also, if there's any seizures of federal or state tax refunds, that we will not address that either. And we do, another thing we do not do is stop an enforcement action until the funds become available. It's really no way for us to do this. And then the late discretionary hearing. So how that late discretionary affects the board is if the administrative hearing, if Judge Neely gives the taxpayer a late discretionary, we will not do anything on that either. We will wait until that is resolved. Next slide. Okay, so this is getting back to our forms, and I've attached a link to this presentation. So that's where the beginning process at the board is the BOA-1, that's the Board of Appeals petition. And once that's filed with us, then that's kind of what gets your case started. We docket it, you get a docket number, and you get an automatic letter that's sent out that says, we've received your case, the process has started. And so, like I had said, there's the BOA-4, and that is attached for all cases that are offers in compromise. And it's basically the financial disclosure and the documents that we require before we even give jurisdiction. And the same thing with the BOA-5, that's the business the ongoing business financial disclosure. And one thing I would say here is, a lot of times I would stress to try to be as accurate as possible on these forms because, for example, I've gotten ones that show, 0 for everything. It's not 0. If it was 0, I can see it's not 0 from the access to information. So when you say, groceries, 0, well, you're eating, you're spending something on groceries. And so it should really be commensurate with what is close to what your actual expenses are. And then on the flip side, not overinflated either. For example, sticking with the groceries example, if you're one person, your groceries for the month, I would find it very hard to believe are $2,000 if you're one person buying groceries. So again, we really do take a very detailed look at what you've put down, and the closer we can see that you are to trying to be accurate, the better off it is for you. Okay, so offer and compromise filings have to be accompanied by the BOA 4 or the BOA 5, federal and state tax returns. On this, I would say we want to see all schedules. A lot of times people just try to send in the first 2 or 3 pages, but it needs to be your full return. And then 6 months worth of bank statements, and it needs to be all your bank statements, not just one. If you have several, if you have a checking account, a savings account, all of the statements need to be attached. Your 2 most recent pay stubs, again, that's in a BOA 4 situation. And then any information showing if you're also trying to work with the IRS and getting a compromise on perhaps some liability that you owe with them, we would want to see that information too. Next slide. With regards to the information, again, sometimes we'll ask for something else depending on your specific situation. For example, if you are having, saying because of the medical hardship, you are not able to pay the amount that you owe to the state. To be very clear, I don't want to see any documentation showing what your condition is. I just need to see that you are, that money is going towards paying medical bills. Okay, and then the taxpayer can represent themselves at the Board of Appeals. They often have a power of attorney. One thing I would say here, we have a power of attorney unit. It's rev.poa, I don't want to say the wrong email address, but we do have that unit, and it makes it a lot easier for us if you go ahead and get that power of attorney approved before you file your petition with the board. That way we don't have to, that's another reason why your petition could wait, because we have to get the power of attorney unit to say, okay, this is a valid power. Next slide.
Rebecca, if I could interject again, question that came in, can you submit an OIC based on doubt as to liability? For example, the taxpayer missed the deadline to dispute a liability, but has facts that would support that the liability shouldn't have been assessed. If so, are financial disclosures required with such an OIC?
Okay, so that's a 2-part question. Number 1, we absolutely will not review tax liability and review any audit. It's a finalized, as far as we are concerned, it is a finalized liability. That is what you owe. We are not going to go back and re-audit you or open the audit. If you want to do that, and many people do, and they have a good reason to do that, you need to go to the chief ALJ and say, hey, someone got it wrong here. This is why I missed my protest period. Can I please get in so that I can have someone hear why this liability is not correct? So that's part 1. Part 2 is any offer and compromise, we are asking for financial disclosures. Again, the underlying premise is you are coming to the board and asking the board to relieve you of your liability to the state. So we want to see that that's actually why we should say, or why I should recommend to the director, taxpayer should have their liability reduced, and here's the reasoning for it. Okay, so the next is 3 ways you can file with the board. And again, for people who come to the board frequently, and I talked too long as usual, but the preferred way now is to email your petition and all of your supporting documents. It makes it a whole lot easier for us to attach those documents to our case manager. It makes things run much more smoothly. We will also, of course, always accept in the mail. And then if you absolutely must, fax us. I have to keep a fax number on here because there are still some people out there who won't let go. But really, we're moving, we are at the point where you should be emailing these documents. It's just a smoother, easier flow. Hopefully, eventually, one of my goals is to move to being able to file online totally. And that means not even being able to submit your petition unless you've attached all the correct documents that we've asked for. But that's down the line. For now, the very preferred way is through our general mailbox. And then once we receive it, you do get that notice of receipt, and then it goes to the jurisdiction process. Once we've granted jurisdiction, next slide, then there's a determination of, hold on, next slide, we only want one copy. Please don't file multiple copies, it throws everyone off. Next slide. Next is the TRO. So our jurisdiction unit within the board looks at what you've presented to see if the board can take jurisdiction. Also within that, on the petition, you can ask for a TRO, temporary restraining order. And what that does is stop or halt the collection process if we think it's warranted. I think perhaps in the past, the practice was we'll just ask for a TRO and collections will stop. I'm being a little bit more selective on granting TROs, and only if I feel that it's warranted. And there's also whether or not you're going to get a conditional or unconditional. Again, I think perhaps previously people thought they could come to the board and let their matter sit for a long time without being collected on and just pay a minimum payment. I'm again trying to kind of steer clear of that. So we are trying to make very educated decisions on TROs and whether they'll be conditioned on a payment, or unconditional, saying you don't need to make any payments. Next slide. It's a lot of information on TROs that you can probably read through yourself. If you have any questions on a TRO, again, please reach out to me. And then regardless of if a TRO is granted or not, or if it's conditional or unconditional, taxpayer has to stay in compliance with their current tax liabilities. And so if you fall out of compliance, we'll give you a little bit of time to kind of get back in line with what you should be filing. And then ultimately, if you're not doing that, then we will dismiss your case. Next slide. On the BOA-1 petition, there's a place where you can request a hearing. You don't have to have a hearing if you don't want to. All that means is you are verbally going to tell the hearing officer and explain your case to the hearing officer. There's a lot of cases that are done without a hearing. And before the pandemic, those were all held primarily in person, but now they're all held primarily via WebEx, but it's up to you. We take any kind of hearing. If you want to come in person, that's fine. If you want to do it WebEx, that's fine too. Next slide. Once the hearing officer has made his or her recommendation, they will send me the draft board order. I'll review the case, I'll review the recommendation, and I will sign off or not sign off on their order. And then from once I sign it off, if it needs only my signature, there's a threshold where I have the authority to sign off on. And if it is over that authority, then it goes to the 3 board members, or to the 2 other board members, and then to the director. Next slide. I think you can read through what we can and can't do, and I think I touched on most of these. We cannot overturn a criminal conviction. And also another thing, once your case or your client's case has gone to an outside collection agency and a fee has been attached, we cannot waive that. That is a cost, a direct cost that the department is incurring, and so we are not, I have in very limited circumstances waived that fee, but for the most part, a collection fee, once it's attached to your liability, will not be waived.